The other two important leading cases, and these are the English leading case relating to law of contract. One is Brainy versus Van Thuwen in 1880, and the second one, London and Northern Bank 1900, relating to law of contract. So, in the first leading case, that is Brain versus Van Hoven in 1880, the very fact of the case was on October 1st, defendants wrote from Cardiff to plaintiff at New York, offering goods for sale. The plaintiff received the offer on the 11th and accepted by telegram on the same day and by letter on the 15th of October. On the 8th October, the defendants posted to the plaintiffs a letter withdrawing the offer. This was not received till the 20th of October, as the offer had been accepted before the withdrawal was communicated. It was held that there was a binding contract, a revocation being imperative until communicated, as the very defendant was revoked the very contract, but it did not came into the knowledge of the plaintiff before the very issuance of the letter of acceptance. So, in the next important leading case, that is London and Northern Bank in 1900, the very fact of the case, one Jones applied for shares in the London and Northern Bank. On October 26th, he withdrew his application. His letter of withdrawal was received by the company at 8:30 a.m. on October 27. At 7:30 a.m., the company had handed a letter of allotment, which is acceptance, to a postman to post, but the letter was not actually posted till after 8:30 am. As for example, after the revocation of the offer had been communicated to the company, the acceptance was too late, as the letter was not actually posted till after the offer had been revoked. Of course, if the letter of acceptance had been actually posted before the letter of revocation reaching the bank, the acceptance should have been binding as against the proposer, as it was held in this very important English leading case, London and Northern Bank, which is regarding acceptance of the offer and very revocation of the offer. So, in another important leading case that we will discuss, and that is relating to LIC of India versus Virginia D'Souza in 1995. So, where it was held that in this case of life insurance policy, merely receiving proposal with premium amount which was kept in suspense for compliance with formalities does not amount to acceptance of proposal. In the instance case, the deceased husband of claimant proposed to get himself insured by paying certain amount to LIC for which a receipt was issued and the amount was kept in suspense pending acceptance of the proposal. The husband died after a month of making proposal. The wife claimed from LIC the sum assured rupees 50,000. The Bombay High Court held that mere acceptance of premium amount and issuance of receipt would not mean acceptance of proposal, and hence there was no concluded contract. And regarding that leading case, Soul will discuss another important leading case, and that relates to the same LIC of India versus Prasanna Devraj in 1995. So the very fact in the instance case, the proposer, a husband of the claimant, filled out the form of proposal for insurance on his life for a sum of Rs 2 lakh and sent the same along with a check for first premium of the divisional office of the Life Insurance Corporation after getting himself medically examined by the doctors. The divisional manager encashed the check and acknowledged the same by granting the receipt. The check sent by the deceased was encashed and held in deposit in the suspense account and not adjusted towards the premium since the proposal was sent for assurance of a sum of rupees 2 lakhs. The ultimate authority to consider its acceptance was the central office of the corporation. It took time to complete the process. The proposer, however, died before it was considered by the authority competent to accept the proposal. When the plaintiff put forth her claim for assured sum, it was alleged by the divisional manager that the proposal by her husband was not accepted by the corporation and hence the contract was not complete. The corporation therefore declined to pay the amount as claimed. So it was held by the Kerala High Court that there was no acceptance of the proposal creating a concluded contract. Firstly, amount remitted was not treated as premium. Secondly, the receipt nowhere spells out that receipt of the amount which was the initial deposit towards the proposal signifies the consent of the insurer to accept the offer or the proposal. Moreover, at no point of time the acceptance of the proposal was communicated by the corporation to the deceased. Hence, it cannot be said that there was The concluded contract of insurance between the corporation and the deceased before his death. Therefore, in the absence of such a contract, the corporation would not be liable to pay the amount to the plaintiff as claimed by her, as it was held by Kerala High Court in this leading case, LIC of India of Trivandrum versus Prasanna Devraj in 1995.